Think your divorce would be over in a few weeks? Think again. Arizona has a conciliation period, which is a 60-day period at the beginning of your dissolution case that you cannot get divorced in. The reason that was created is back in the day, we were having a lot of parties who wanted to get divorced, and they would quickly go down, execute the paperwork, sign on the dotted line, and they would be divorced. A few weeks later, they would realize maybe that wasn't the best decision, and they would go back to the court trying to undo their divorce to find out that's not as simple of a process. So Arizona initiated this 60-day conciliation period that basically is a waiting period for you to be able to get divorced. Now in Arizona, a typical divorce case will take anywhere from 6 to 8 months to finalize. Of course, there are situations where if both parties are really amicable and you're guided by good legal counsel, where we can get you through that in 3 to 4 months, but a standard divorce will take anywhere from 6 to 8 months, and certainly high complex divorces, high net worth divorces, things that are involving children can often take a little bit longer, but those types of cases can certainly take longer than that average of 6 to 8 months as well. Wanting to get divorced but don't know where to start? I'm going to give you a quick guide of what to expect during the divorce process. In Arizona, divorces typically start with the filing of your initial petition for dissolution. So one party's going to decide, I'm ready for the divorce, and they're going to file that original petition. At that point, you'll have to serve the other side with the petition so that they have knowledge that you've initiated the proceedings. They'll then have an opportunity to respond to your petition and your allegations. After they've submitted their response, the court will typically set what we call a resolution management conference. A resolution management conference is just a short 5 to 10 minute hearing. It's a procedural hearing where we just discuss the procedures of the case. So we're not talking about the substance. This is not an evidentiary hearing or a trial. Typically, your attorney will do most of the talking for you during that resolution management conference. At that point, your case will typically undergo what we call the discovery and disclosure process. We want to figure out what your assets and debts look like, what your goals are for the case, so that we can start prepping for final resolution. Once we have the discovery and disclosure complete, because Arizona is a complete disclosure state, meaning there are no surprises in the state of Arizona, you can't hide assets or debts from the other party. But once we have those things complete, we're going to shift into the mediation or the attempted settlement portion of your case. It's always better if we can come to agreements with the opposing party directly, rather than having to go through the court and have the judge make a decision pertaining to your property and your children. It's always better if we can lay out those guidelines and get them drafted up for you so that you guys can work through the more finite details. If we're not able to resolve your case at mediation or through settlement, we start to gear your case up for trial. And at Desert Legal Group, that's what we do. We hire really good trial attorneys. That's our primary focus. It's really what we do. If you look at our reviews online, you'll see that that's really a big focus for our law firm. But when your case needs to go for trial, we want to make sure you're prepared for trial. You know exactly what you're walking into, and that we're able to present the best case we can in front of the court. Regardless of what stage you're at in the dissolution proceedings, we're here to help. Reach out to us at Desert Legal Group. We'd love to chat with you about your case. The family court process in Arizona can be really intimidating. Knowing exactly what documents you need to enter that process can be really helpful for your case. Some of the documents that can be really helpful for you to have at the beginning of your divorce could be financial documents. Evidence of financial accounts pertaining to either your accounts or the opposing party's accounts can be really helpful for you to have when you enter that process. Additionally, having things like schooling records, medical records, dental records, things pertaining to your children, it can be really helpful for you to have those things documented and already set aside at the beginning of the dissolution process as well, because we will need them during that process. Would you prefer to mediate or face off in court? To answer that question, I should start with defining what is mediation. What should we expect walking into mediation? Mediation in Arizona is typically a situation where both parties are going to sit down at a table, usually with attorneys, although there are circumstances where your attorneys will not be present, and you'll have a third-party mediator that sort of goes back and forth and tries to help each side come to agreements during the case. Mediation can be really helpful because you and your attorney in some circumstances can actually outline the exact terms of the agreement. If you go in front of a judge and you litigate the case, it's risky because the judge is going to issue final orders for you and you don't get to have a say in exactly what those orders are going to be. You're stuck with what the judge decides. Mediation gives you a lot more flexibility to be able to get creative and to really have options that work for you and your family. Any questions about what to expect in Arizona divorce court? If so, give us a call.